Cool, guys, we'll go ahead and get started. Is everyone ready to learn? Was lunch good? Thumbs up. Oh, good. Wait, hold on. No thumbs down? Oh my gosh. You should, Ashton, I saw your face. Cool, so we're gonna go ahead and talk about Title 18 Criminal Code for BAP agents. So please welcome Tara.
Thank you, Taylor. Good afternoon, everyone. Welcome back from lunch. Hope you're nice and energized from your break. My name's Tara. I'm with the Attorney General's office. Before this, I was a district attorney in the 18th Judicial District. So I did that for about 8 years. Feels like another lifetime. But yeah, that's my criminal experience. So we're going to dive in. We have a lot of material to cover. So our roadmap for today, we're briefly going to cover the difference between civil enforcement and criminal enforcement. Then we'll move on to the source and scope of your limited peace officer authority under Titles 16 and 35. Then we will move on to Title 18, which will be the meat of this presentation, getting into specific animal crimes, defining the mens rea associated with each of those, distinguishing between felonies and misdemeanors, which will be very important for you, outcomes and penalties that you can expect from those cases once they work their way through the court system, and then restitution, impound, and cost of care. And then finally, we'll get to constitutional considerations. I feel like each of these could probably be like a whole hour, so this will be like a mile wide and an inch deep, but hopefully it will at least give you some reference points as you move forward with your work. So I think a good starting place is your mission and purpose under the statutes, under Title 18 and Title 35. Your agency essentially serves as a support mechanism to local law enforcement agencies in conducting animal neglect, mistreatment, abandonment, and cruelty investigations. The tools that you have in your toolbox to carry out that mission really fall into two buckets, which is civil enforcement and criminal enforcement. I will be going over the criminal enforcement side, but keep in mind that that distinction isn't always going to be clear-cut, and the same set of facts could actually support pursuing either route. But the goal of sort of this conference, one of the goals anyway, is to allow you to distinguish between the two of them and different factors that you can take into consideration in determining which route is most appropriate to pursue under any given set of circumstances. So our flow chart, just questions that you should ask yourself when you're out in the field. The first one is going to be, is this civil or criminal? Again, not always clear-cut, but once you decide on the most appropriate route to take, you'll have another fork in the road, so to speak, to decide whether you're looking at a misdemeanor or a felony, which will dictate whether you can investigate on your own and issue a summons and complaint if you're in misdemeanor land, or if you're in felony territory, if you need to get local law enforcement involved. And this will be an evolving question as you go through an investigation. What starts off as a misdemeanor could end up as a felony as you get more information. Let's say you look into someone's criminal history, or injuries turn out to be more extensive than they appear at first blush. You might go from misdemeanor to felony, in which case you need to get local law enforcement involved. In terms of our major concepts for the scope of criminal authority, we're going to start with where your peace officer authority comes from, and then we'll move on to our Title 18 stuff and then constitutional considerations. So your authority essentially comes from 16.2.5.118, which actually designates you as a peace officer while engaged in the performance of your duties in enforcing the provisions of Title 18, Article 9, which is the animal cruelty stuff, as well as Title 35. So you have peace officer authority when working in these sort of confined arenas. But remember, under the BAP rules and 16.2.104, that is really limited to investigating and enforcing misdemeanors only. But your role in felony investigations is really important as well, both in terms of being a partner, a witness, an expert, and building that partnership as you go will be really important to creating a really strong investigation. I don't expect you to memorize this at all, but these are the major provisions of 18.9, 201 through 209. This is essentially all of the animal crimes. I'm going to dive into some of the major provisions in more detail. Considerations in charging cases. This presentation will essentially just focus on the state level crimes, but know that you could be looking at local codes and ordinances and regulations at the county or city level, and then you also have the state codes layered on top of that. And you might even have some federal stuff thrown in there too. So this really is like a layer cake with 3 different layers. We're focusing on state, but be aware that you may be looking at local ordinances as well. So in terms of distinguishing misdemeanors and felonies, the majority of the animal cruelty crimes do fall under an M1, which means that they will be written into county court. If they go to trial, they will have a jury of 6 rather than 12. All of these will be probation eligible, and probation is the likeliest outcome for most of these misdemeanor cases. The most jail you could be looking at would be 18 months. The range is 6 to 18 months jail. In my experience, I think jail is an unlikely outcome except for the most serious cases, and a pre-sentence evaluation will always be required. In felonies, you're going to be looking at district court. If it goes to trial, that means a jury of 12. I think it is always harder to get 12 people to agree on something than 6. It does have to be a unanimous verdict in both situations. If you think about trying to get a room full of people to even decide and agree on, say, pizza toppings, you get an idea of what jury deliberations are like. It's really hard to get 12 people to agree on anything. 6 is maybe a little easier, but the aggravated animal cruelty is a class 4 felony, so is animal fighting, and then a second conviction of what would normally be considered the M1 animal cruelty will be elevated to the F6. Again, all of these are probation eligible. The F4 is the sentencing range, could be 2 to 6 years of DOC with 3 years of mandatory parole. Again, DOC I think is an unlikely outcome except for the most aggravated cases. With the second conviction, there is a 90-day jail or in-home detention sentence that is statutorily mandated. And this would be if there's a DOC sentence between 12 and 18 months, followed by 1 year of parole. Pre-sentence evaluation is required, just like in misdemeanors. And then for any felony conviction, whether you're looking at the second conviction, that's an F6, or the aggravated offense, which is the F4, the statute actually prohibits the defendant from owning, possessing, or caring for a pet animal for a period of 3 to 5 years as a condition of their sentence, unless, and there's always an unless, the defendant's treatment provider recommends against the ban and the court agrees with it. So both of those things would have to be true in order for the court to circumvent that requirement. Okay, we're going to dive into animal cruelty. The main mental states associated with all of the animal cruelty offenses are going to be knowingly, recklessly, or with criminal negligence. And knowing the difference between each of these and what evidence you might be able to gather that supports each of these will be important. There are sometimes different consequences associated with the different mental states. We'll get into it later, but for a particular provision, the distinction from knowingly to recklessly or with criminal negligence will be the difference between a felony and a misdemeanor, which is very important for you all. So knowingly means that the person is acting in a way that they are aware that their conduct is practically certain to cause the result, Recklessly is one step below that, where the person is consciously disregarding a substantial and unjustifiable risk that a result will occur or that circumstances exist. Criminal negligence means a gross deviation from a standard of care or failure to perceive a substantial and unjustifiable risk that a result will occur or that circumstances exist. Note that just because it's a lower level of culpability, say criminal negligence versus knowingly, doesn't mean it's necessarily any easier to prove. In fact, I think criminal negligence is particularly tricky because you will almost certainly have to have an expert witness testify as to what the standard of care is and how the defendant deviated from that standard of care. So that actually adds in another layer of something that the DA is ultimately going to have to prove at trial. So then the question, of course, comes up, how do you establish what is inside someone's head, which is tricky. But establishing mental state, you can use a variety of different kinds of evidence, some circumstantial and some direct. You can talk to a suspect if they're willing to engage with you. There are going to be some constitutional considerations that we'll go over later, but talking to them is really the most direct way to get at what they're intending or thinking. A suspect's history can be really helpful in terms of establishing what they know or don't know. Perhaps they've had a history with the department. Previous agents may have documented conversations that they've had with this particular suspect and advise them, no, with this breed of whatever animal, you can't be doing this. And so if you have that documentation, whether that is a conviction or not a conviction, even just the department having previous contacts with a particular suspect, that can be really helpful in establishing knowledge and intent. Talking to other witnesses, did they hear any statements of the suspect or witness the suspect's behavior? Maybe they've witnessed this repeatedly, and that could help in establishing that this wasn't an accident or a one-time thing, that this is something that this person engages in deliberately. And then other circumstantial evidence that either makes it more or less likely that the suspect intended or didn't intend for a certain outcome to occur. So the animal cruelty statute, the way it's written, applies these mental states to a whole laundry list of conduct, and all of these will be the class 1 misdemeanor. So I'm going to go through these sort of broadly, and then we'll get into the details a little bit more. But the first one is overdrives, overloads, overworks, torments, deprives of necessary sustenance or unnecessarily or cruelly beats, allows to be housed in a manner that results in chronic or repeated serious physical harm, carries or confines in or upon any vehicle in a cruel or reckless manner. An example of this might be left in an overheated car, an overcrowded semi, animals left unsecured, or other gear around an animal in a vehicle that's not secured that could harm the animal, engages in a sexual act with an animal, otherwise mistreats or neglects any animal, or causes or procures that to be done. And this is an interesting distinction between criminal and civil. Under the civil rules, you would separate out mistreatment, neglect, and abandonment from cruelty. And under the criminal laws, there's no difference. It all comes under the same umbrella as cruelty. Having the charge or custody of any animal and failing to provide proper food, drink, or protection from the weather consistent with that species, breed, and type of animal. And that's an important distinction as well. Certain breeds might have different requirements, like flat-nosed dogs have different requirements in terms of weather and their tolerance for that. That sort of thing is important to consider, and abandons an animal. And then the case law in this area is interesting. It says that actual malice is not required to prove any of these offenses. So what that means is that you would have to prove that the person knowingly, recklessly, or with criminal negligence engaged in any of these behaviors, you don't have to prove that they set out with the objective to harm the animal, just that they knowingly or recklessly or with criminal negligence either abandoned the animal or didn't provide sufficient food and water, etc. Malice is sort of an added layer that you don't have to prove out of the case law. And then under 1B, we have any person who intentionally abandons a dog or cat. 1.5A, we have recklessly or with criminal negligence tortures, needlessly mutilates, or needlessly kills an animal. Again, both of these are the class 1 misdemeanor. Note that with 1.5A, the mental state here is specifically recklessly or with criminal negligence. There is a separate provision that says if this is done knowingly, it's elevated to aggravated animal cruelty, which is the F4. And here we are at aggravated animal cruelty. So we have, again, a person who, knowingly tortures, needlessly mutilates, or needlessly kills an animal. This would require mandatory jail or in-home detention of 90 days and a comprehensive evaluation, and any treatment that is recommended from that evaluation is statutorily required under 18.9.202 2A3. In terms of sentencing for the M1, which is the majority of the offenses I think you're going to see, they are probation eligible, and this is the most likely outcome, in large part because I think judges want to address the root behavior that's causing this. They want to educate, rehabilitate, and prevent recidivism in the future. And I think most judges would want to prevent it from happening again, and a jail sentence may or may not do that. So the evaluation is required for both the misdemeanor and the felony. The court may order anger management, mental health, or other appropriate treatment under the statute. 6 to 18 months jail is possible, but unlikely unless it's a very serious offense. For felony sentencing on the F6, which would be the second conviction of what would ordinarily be the M1, evaluation and treatment are required. For the F4, you have that 90 days mandatory jail, and then an important distinction for the felony conviction involving animal cruelty, and this is for either the F6 or the F4. So whether aggravated or not, the defendant is prohibited from owning, possessing, or caring for a pet animal for 3 to 5 years, unless the defendant's treatment provider recommends against the ban and the court agrees with that recommendation. So I thought I would throw in a few hypotheticals here. I'm going to read a set of facts, and anyone can throw out an answer. Maybe Taylor can bring around the microphone if someone wants to volunteer here. So the scenario is that a companion horse is seen on an owner's property from the side of the road. It is enclosed but visible from the road. The horse has redness and an odd shape on its muzzle. The agents go to the fence and are able to view, without crossing the fence, that the halter is actually embedded in its skull. So the first question is there probable cause to investigate a criminal case? And 2, is there sufficient evidence to investigate a civil case? And it might not be one or the other, but any thoughts from the audience? Yeah.
I have an answer.
I definitely heard the right answer from several people. So the answer is yes to both. And again, there can be parallel tracks going at the same time. There might be a civil and a criminal, or you might decide under the circumstances that a criminal case would be the fastest, most expedient way to take action. But it's not always going to be clear-cut, one is right and one is wrong. In this case, the answer is yes to both. Second hypothetical, the scenario is that the owner of this dog, say, is driving under 25 miles an hour with the family dog riding in the flatbed of the truck with other camping gear and tools loose in the bed of the car. Has this person committed animal cruelty under Title 18? Any thoughts? And I think a better question is, what does it depend on? So what questions might you ask in investigating a scenario like this? Maybe you would want to know, how long was the dog back there? Are we talking 5 minutes? Are we talking 5 hours? Is the dog in a kennel? Is the kennel secured to the truck? Is the gear secured in any way? Is there a person back there who's securing the dog? What are the weather conditions? Are we talking extreme heat or cold? Is it snowing or raining? What breed of dog are we talking about could matter. What kind of terrain you're talking about could matter. Maybe you're driving slowly across an open field in your ranch, or maybe you're driving down I-25. Makes a big difference. So these are the types of factors that you should be considering in determining whether a criminal offense has been committed. And these are the types of questions that the DA is probably going to have for you as well. Another scenario, we have an owner who is marathon training with their dog. The dog is limping, repeatedly stopping, and appears to have a badly injured paw. And the person keeps trying to get the dog up to run again and again so they can complete their marathon training. Has this person overworked their dog and committed animal cruelty under Title 18? Probably yes. Again, information you might want to gather is, the breed of the dog, what kind of shape the dog is in, if they're used to this kind of conditioning, if they're getting breaks. Maybe they're under vet orders for rehab. Who knows? But I think asking the questions and getting as much information as possible about all of the attendant circumstances is really important in these investigations. I think the answer would probably be yes in this case, but more information is always better. Moving on to animal fighting under 18.9.204. This is a Class 4 felony, and the basic language of the statute is that no person shall knowingly, and again, knowingly is our mens rea here, or our intent element, cause, sponsor, arrange, hold, or encourage a fight between animals for the purpose of either monetary gain or entertainment. So with the encourage element, there is case law that says that the person would have to knowingly encourage the fight or knowingly attend the fight. If someone happened to be at a fight and they told officers, well, my friend just told me we were going to a party and I didn't know that this is where we were going, that might not meet the knowingly element. They have to go with the intent of actually going with the purpose of being at this fight. And the elements are that the person owns, trains, transports, breeds, sells, transfers, or equips a fighting animal. Mere possession is enough, but you do have to prove an intent for the animal to engage in a fight ultimately. In terms of encouragement, this could be proven in a number of ways. We have allowing a fight to occur on your property or property controlled by you, allowing a fighting animal to be kept, boarded, housed, or trained on or transported in any property owned or controlled by you, and using any means of communication for the purpose of promoting a fight. I could envision this happening on social media, for example. Sentencing for animal fighting. Oh, excuse me, this is an F5. I misspoke earlier. So an F5 is probation eligible, possibility of 1 to 3 years DOC with 1 year of parole. And remember, a felony case could be charged through a summons and complaint, but it has to go through the district attorney or local law enforcement. This is not something that you could write a summons and complaint for yourself. But you would be an important partner in terms of being a possible witness or an expert in the investigation. So another hypothetical here, the scenario is that two dogs are made to fight, but it's stopped before any serious injuries occur. Do we have animal fighting? The person who promoted and organized this fight stopped it before any serious injuries occur. Does that matter? Any thoughts? You guys are so good. It does not matter. You didn't fall for it. Injury is not necessary. If we change the facts up just a little bit and the person who organized this fight doesn't own either of the dogs that were engaged in the fight, isn't present during the fight, but posted on Facebook about it. Have we met the encouragement element? Probably, yeah. All right, dangerous dog, 189204.5. I think a good thing to be mindful of is that in addition to the state statute for dangerous dogs, many counties and municipalities have a dangerous dog or vicious dog provision that you'll also want to be aware of. So a person commits ownership of a dangerous dog if they own, possess, harbor, keep, have a financial or property interest in, or have custody or control over a dangerous dog. And dangerous dog is defined as any dog that inflicts either bodily or serious bodily injury, and those two things are defined differently, or causes the death of a person or another domestic animal, or demonstrates tendencies that would cause a reasonable person to believe that the dog may inflict bodily or serious bodily injury or cause death to any person or domestic animal, or engages in or is trained for animal fighting. And restitution is mandatory upon conviction of a dangerous dog offense. So in terms of sentencing, this will largely depend on the type of injury incurred as well as the defendant's history. If a dog inflicts bodily injury, which is defined as really even just pain, is sort of the lowest threshold that would meet the definition of bodily injury. But bodily injury is statutorily defined under Title 18 as any physical injury that results in bruising, muscle tears, skin lacerations. It may require professional medical treatment or not, but even just causing pain would meet the threshold of plain old bodily injury. This would be a Class 2 misdemeanor, and the dog is not euthanized after the first offense, but is required to be euthanized after a second or subsequent conviction. Serious bodily injury is pretty narrowly defined under the statute, and you will usually have to have a physician sign off on this. Most law enforcement agencies will have a template form for SBI with the definitions listed out, and the physician can actually check the boxes, which ones may apply, and sign off. And without that, it's really hard to prove the narrow statutory definition of this. What we may think of as serious injury, in our everyday lives, may not qualify under the narrow statutory definition. So, serious bodily injury, or SBI, as we often refer to it as, includes bodily injury, which either at the time of the injury or later on, so it could evolve, involves substantial risk of death, substantial risk of serious permanent disfigurement, and it has permanent disfigurement. So a scar that fades or a bruise that fades probably wouldn't cut it. A substantial risk of protracted loss or impairment of the function of any part or organ of the body, breaks, fractures, or burns of the second or third degree. This was also amended, I think, 2 years ago to include penetrating gunshot wound, which would not, be applicable here, but that's also in the statute. This is an M1, so one class of misdemeanor above just plain old bodily injury. The dog is required to be euthanized after the first offense if serious bodily injury is sustained. And then if it is a second offense, whether there's SBI or not, that's elevated to an F6, and the dog is required to be euthanized. If the person dies ultimately from their injuries involving or resulting from a dangerous dog, that's elevated even higher to an F5, and the dog is required to be euthanized. If you have injury or death of another domestic animal, it's an M2, and the dog is not required to be euthanized unless it's a second or subsequent conviction. And then damage to property is considered a Class 1 petty offense. There are some exceptions to the dangerous dog offense, which is the primary one that you'll probably encounter is that the dog was defending itself, its property, or its owner from another's attack, or the dog is provoked. And any dogs that are used in the course of law enforcement duties, if it's a law enforcement canine, that's exempt from all of this. You might see injuries sustained by a veterinary healthcare worker or a dog groomer or humane agency personnel, a professional dog handler or trainer. This would be exempt unless the owner knew that they had a dangerous dog and failed to comply with notice requirements from a previous conviction. And then the last exception would be injury or death to a domestic animal that's naturally associated with the work of such dog. So if we're talking about a hunting dog that comes back with a dead animal, that might be applicable depending on some other attendant circumstances. So speaking of which, in this hypothetical, we have an owner who's out hunting with their hunting dog. He has a permit and he's on his own property. The dog comes back with a dead chicken. Do we have a dangerous dog offense? And what questions might you ask and what might it depend on? I'm hearing lots of mumbling, and it all seems to be trending in the right direction, which is that the question that you would really want to get the answer to is whether the chicken was on the defendant's property or if it belonged to a neighbor and the dog had strayed onto the neighbor's property. That might make a difference. And then if we change the hypothetical and we have owner A who's out walking their dog when owner B's dog runs up and attacks owner A. Owner A's dog attacks and kills owner B's dog. Do we have dangerous dog? Right, probably not. It sounds like in this situation we would have an affirmative defense that owner A's dog was defending itself and its owner. Okay, impounding an animal under 189-202.5. Under the statute, where a commissioned agent has issued a summons and complaint for an alleged violation under this section, the commissioned agent may take the dog into custody and place it into a public animal shelter. You cannot impound, however, unless you are the one who has issued the summons and complaint. And there are a whole host of procedures that come along with that. When an animal is impounded by law enforcement due to an investigation under Title 18, the owner of that animal may file payment to prevent the disposition of the animal by the impound agency by providing for the animal's care and provision for at least 30 days at a time. Payment has to be renewed 10 days prior to the previous payment's expiration. The owner may file payment to request a veterinarian to examine the animal for photographs or biological samples. And the animal must be picked up within 5 days from release. And another good thing to keep in mind is that a BAP agent cannot impound unless it's pursuant to the misdemeanor dangerous dog statutes, and otherwise this has to be done by local law enforcement in that jurisdiction. So the impound hearing has to occur within 10 days after the initial impoundment. The owner or custodian may request a hearing by providing notice to the DA in their jurisdiction. And that hearing has to be held within 10 days of the request. The judicial determination will be whether probable cause exists that the offense occurred. And then at the cost of care hearing, which will also take place at the same time, the judge will determine whether the cost of care associated with the impoundment is fair, reasonable, and necessary, which costs shall be itemized by the impounding agency, whether there's sufficient probable cause for the impoundment, whether the animal should be released to the impounding agency for lack of payment. And then if the court does in fact find that there's probable cause for the impoundment, and the owner or custodian elects not to pay those reasonable costs of care, then the impound agency can essentially dispose of that animal as it sees fit. All proceeds from a sale of an impounded animal are first applied to the cost of the sale, followed by the care of and provisions of the animal during impoundment. And that includes any costs not covered by the defendant. If the defendant is ultimately found guilty of the offense that they're charged with, the remaining proceeds are paid to the impound agency. If the defendant is found not guilty, the remaining proceeds are paid to the owner of the animal, and notice must be provided to the owner at least 6 days prior to sale. Okay, one more hypothetical. The defendant would be responsible for these costs while impounded, true or false. We have a specialty brand of dog food, for example, that is twice as expensive as ordinary dog food. Any thoughts? Maybe. What about basic vet needs? Any thoughts of that? That's false. That's a tricky one, I think. This is actually considered a separate cost. So the defendant would be on the hook for reasonable costs of care, but not veterinary costs, which is, I think, not an intuitive distinction. And then the difference between cost of care and restitution, true or false? They are the same thing. Yes, that's an easy one. I feel like I kind of set that one up. The difference is that restitution is designed to make the victim of the crime whole, and that can go to any person or entity. It can be an organization or a business that incurred a monetary cost as the result of an offender's criminal conduct. This is different from, say, pain and suffering or emotional distress that someone might seek through a civil lawsuit. We're not looking at that at all. We're only looking at actual costs that the victim sustained. All right, constitutional considerations. This will all come from the 4th, 5th, and 6th Amendments of the United States Constitution. The state of Colorado has the equivalent provisions essentially in its Constitution. I'm going to spend the most time on 4th Amendment, which protects everyone from unreasonable search and seizure. And taking an animal is considered seizure of a property in violation of the 4th Amendment unless you have probable cause to believe a crime has been committed or you have a warrant. We went over this a little bit at the beginning when we talked about Title 16, but in terms of search warrants and investigations, if you need a criminal search warrant, you should be getting local law enforcement involved. This is under the regs for BAP, but yeah, if you need a criminal search warrant, you need local law enforcement involved. The extent of your authority is really to investigate and issue summons and complaints for misdemeanors. So keep that in mind. This is a huge body of case law around search and seizure and the expectation of privacy. And it's always going to center around the question of a reasonable expectation of privacy. The courts will evaluate nuances on different contexts and different settings, whether we're looking at a hotel room or a mobile home or an automobile, or the glove compartment of an automobile. All of these things have different expectations of privacy associated with them, but that's really the common thread that runs through all of them, and the question that you should always have in the back of your mind. And if there's a legitimate expectation of privacy from unreasonable government intrusion, you need PC or a warrant. Some exceptions to a warrantless search would be, at least the ones that apply to your work, would be plain view, an abandoned place, a consensual encounter, or an open field. There are some others that we are not going to get into because they don't really apply to your work. We'll start with open field and the concept of the curtilage, which is a really strange Old English term that basically means the area immediately surrounding and associated with the home. So this might be a side yard or a front yard or land that's just adjacent to a home. But the court considers this as part of someone's dwelling that they have an expectation of privacy in. And to determine if something is part of this curtilage area, the court would consider its proximity or annexation to the dwelling, its inclusion within the general enclosure surrounding the dwelling, and its use and enjoyment as an adjunct to the family's home. So an open field is exactly what it says, an open field. This is not considered part of someone's dwelling. Someone does not have an expectation of privacy in an open field. And that may include unoccupied or undeveloped area that's outside of a home's curtilage. Plain view, again, is exactly what it says, plain view. And you can consider how plain view and the open fields doctrine work together. If you're in an open field where someone doesn't have an expectation of privacy and you're able to see something in plain view, you don't need a warrant to search it. I think abandoned property is difficult because extreme disrepair on the outside alone wouldn't constitute abandonment. I think the courts are very wary to deem something abandoned just based on its appearance. So you would definitely want to get a lot more information about the occupancy of the property before you deem it abandoned and just waltz right in. Consensual encounters with a person are essentially when someone feels that they are free to leave the encounter. So if you are standing in line at the 7-Eleven, you're in uniform, you're buying a cup of coffee, and you strike up a conversation with the person behind you in line, that's a consensual encounter. They're free to terminate the encounter or leave at any time. This is an objective test. It's made based on, determination is made based on the totality of the circumstances. And it basically means there has not been any sort of show of authority. The person is not detained in any way. A consent search in terms of going into a property when you have permission, the biggest thing to be careful of is who can give consent and what the scope of their consent is. For example, you might have a minor who answers the door who doesn't have permission, doesn't have authority to grant permission, or maybe they're a guest or a relative who doesn't have any ownership stake in the property and doesn't have any authority to grant permission for law enforcement to enter. And they can also define the scope of their consent. They, for example, would be allowed to say, yeah, you can come in, but I'd ask that you stay upstairs and not go into the basement. Since their consent doesn't extend to the basement, you would need a warrant to go into the basement. So in terms of investigation and interrogation, I don't think you all will be doing much custodial interrogation when someone is actually in custody, which is what triggers the Miranda requirement. But I'm going to touch on it briefly, just so you're aware of it if it ever comes up. So for the Miranda requirement to be triggered, you have to have both custody and interrogation. And those are each defined in case law. It's a lot of case law that I'm not going to go into because I think we're getting close to time. But custody has to be formal custody, and interrogation means essentially trying to elicit an incriminating response. It would not include a spontaneous statement. If someone's in custody and they blurt out that they've committed some crime, they haven't been interrogated. That's a spontaneous statement. Whereas if it's the product of questioning whose purpose is to elicit an incriminating statement, we would be in a different ballpark. Custody is going to be a reasonable person test, whether a reasonable person under the same circumstances would believe that they were free to leave and or disregard the officer's request to remain and provide information. These factors, you probably are not going to need a whole lot of detail on this in your work, but this comes from both federal and state case law. When a court is evaluating whether someone is in formal custody for purposes of Miranda, they're going to consider the time, place, and purpose of the encounter, who was present during the interrogation. Are we talking one officer or 6 officers? The officer's tone of voice and general demeanor, was it like a, hey, how are ya? Or like a, very firm, stern, intimidating kind of tone and demeanor? The length and mood of the interrogation, which might be captured on body camera, whether any limitations of movement or other form of restraint was placed on the defendant, whether the officer was armed, whether commands were given to the defendant during the interrogation, the defendant's verbal or nonverbal responses to such directions. And this isn't even an exhaustive list. It can go on, but it is a multifactorial analysis. And then right to counsel, basically if someone asks for a lawyer, you should stop talking to them. That is sort of the short of that. They can waive that right once they've invoked it. I would recommend getting it in writing. And the exclusionary rule means that evidence that was illegally obtained cannot be admitted at trial. That's the ultimate consequence if a court determines that the 4th, 5th, or 6th Amendment has been violated. I had some hypotheticals, but I know we are really tight on time, so I'm going to skip straight to questions and show off my adorable puppies. Any thoughts, questions, concerns? Yes? I did not.
Okay. If the officer doesn't come within 5 days, what happens next? Yep.
So if the owner cannot come within the 5 days specified within the statute, they could request an extension of that time, and the court would have discretion to grant that if they show good cause for that extension. Or if they don't and they don't care, then the agency can basically take whatever appropriate steps it deems for the disposition of the animal. I think that would be the safer approach, and I would talk with your DA about getting something from the court, or at least from the DA, that says that the appropriate time has elapsed.
It's kind of a random question for the Fourth Amendment. I was wondering about drones. I haven't read much case law about it yet, but like there was a case that we had recently where someone was in they're in the second floor apartment, and I was just like, can we fly up a drone? Because like any other person can legally fly a drone if they're in that area. So what's like our standings on it?
That's a really interesting area of case law that's evolving. I don't think there is I don't know of a clear-cut answer. Kelly or Katie, I'm going to put you on the spot. Do you know of any case law that speaks to that directly on point?
You mean using the drone to find probable cause? Yeah. To record and see something that is incriminating?
Yeah. Because like technically normal people can fly it, like if it's an apartment complex, like normal people can be flying a drone. So how's it any different from like a police officer, one of us, doing the same?
Thoughts, Katie? Yeah, I mean, I think there's otherwise held out to the public. I think you have to ask your DA. Ultimately, the judge will make a decision as to whether that's a public cause.
Is there any other questions with cost of care or anything? Cool. Thank you, Tara.
Yeah. All right. Well, we'll call that a wrap. I actually want to look into that drone issue. If I find any good case law, I will email it to Taylor to pass along. Yeah, it's a really interesting issue. The intersection of technology and privacy is a fascinating one. All right. Well, thanks, everyone.